Okay, there's the title. Let's get on with it. Who am I? Well, I've been a chartered accountant for over half a century in a variety of firms. I've done forensic accountancy and so on for the last 30 years. And relevant to today, I've been a mediator now since 1998. Done 115 mediations, not a huge number, but with an 80% settlement rate. And if you look at that list of the subjects that I've had to deal with, I think you will see it's very wide, and it is certainly a lot wider range of subjects than one would normally see for a chartered accountant. Because when you become a mediator, you start with your own field, but you generally then become a generalist. Being a mediator means that you can understand disputes and can help people way beyond accountancy. So who are you? You could be an individual or business with a potential dispute. You could be a lawyer or other professional who may represent clients at the mediation. You may be a new or experienced mediator, or you may be somebody who has not very much to do on Friday the 13th afternoon. Whatever, welcome and enjoy. I don't have all your answers, but hopefully we will all together learn something today. The first thing I think we should ask ourselves is this: is mediation the best way of resolving a problem? If you need to establish a precedent, it probably isn't. And a very early example I remember about that was a woman police constable who was at the equestrian training school in London and said that she'd got whiplash because she'd been thrown off a horse. Her employers didn't accept that at all and rejected every possible approach for mediation, dispute resolution, whatever. No, we're not talking to you. We don't believe you're injured. It went to court, and the employer, the police authority, won the case. Why was it so important that they should stop this woman in her claim? The answer was there was a canteen culture. A lot of the other trainees were feigning whiplash and other injuries as well. And the Metropolitan Police would have had to deal with an awful lot of other claims had they not made an example of this woman who was making it up. So to establish a precedent may be important. Mediation then isn't for you. What about arbitration or expert determination? Well, I'm not going to repeat yesterday's course, but these are methods of dispute resolution where you do get a binding decision. With mediation, it's cooperative, but if it fails, you may have to start again. Is the other party totally uncooperative? If so, we may have to follow the rules in Halsey, where the Court of Appeal found that if an invitation to mediation is refused or ignored, the onus falls onto the party refusing to justify that that refusal was reasonable. And there is a very short checklist of examples in that judgment of what may be reasonable refusals. But if that party fails to demonstrate that their refusal was reasonable, there is a high risk that they would have to pay both sides' costs, irrespective of who won at trial. Let's have a look at some words of encouragement to use mediation from the bench. Now here, I want to talk about Sir Alan Ward, who is a relatively recently retired Court of Appeal judge, who went on to become a mediator and the chairman of the Civil Mediation Council. I know Alan very well because I've actually mediated with him. I led him in my 100th mediation, which was his very first mediation. And you know, he was wonderful, an absolute natural. He had a reputation when on the bench for some very interesting judgments, a lot of them light-hearted. And I've got a blog page on my website, The Bon Mots of Sir Alan. If you've time, have a look at that. You'll need to look at my website to get the link and then go on to that page. It's fantastic, the things that he's said. This is a more serious example of the judicial encouragement he engaged in. In Wright and Michael Wright, you may be able to drag the horse, a mule offers a better metaphor, to water, but you cannot force the wretched animal to drink if it stubbornly resists. I suppose you can make it run around the litigation course so vigorously that in a muck sweat it will find the mediation trough more friendly and desirable. But none of that provides the real answer. Perhaps, therefore, it is time to review the rule in Halsey. Now, this was in 2013, which is 9 years after Halsey. A lot of people have said that Halsey let people off refusing mediation too lightly, that there should be sterner reasons for refusal to mediate and a higher risk of the refusing party paying costs. But that hasn't really happened yet. So let's stay with Alan a little bit longer. This is another quote. Not all neighbours are from hell. They may simply occupy the land of bigotry. There may be no escape from hell, but the boundaries of bigotry can with tact be changed by the cutting edge of reasonableness, skillfully applied by a trained mediator. Give and take is often better than all or nothing. And then I couldn't resist putting the last one in, which is absolutely nothing to do with mediation, but has everything to do with Alan and his attitude to life. Warring bankers. This case involves a number of, and here I must not fall into Dr. Spooner's error, warring bankers. Think about it. Warring bankers. Right. Is it time to choose a mediator? Well, actually, not yet, because there needs to be a mediation in prospect. And if you've got two parties in dispute, both of them need to feel that mediation will help them. I've got a website with videos about how mediation works, and I get lots and lots of people calling me up. They've looked at my video. They think I'm their best friend because they know me now very well. I don't know who they are. And they say, oh, we think you'll be able to mediate my dispute. Fine, what's it about? Da-da-da-da. Yes, and what does the other party think about that? Oh, I haven't talked to them about it yet. Well, you do realise that both sides need to want a mediation. Oh, well, can you talk to them? Not really. 3 suggestions I would make. One of them is we advise the party to have a word with the other side and tell them that mediation may very well get them out of the problem. The second is those of you who saw Mickey Harris's webinar on Wednesday, when the other party refuses, gives us all sorts of techniques on how the other party may be brought to the table. And the third suggestion I would make is this. The Mediator Network itself offers a service at a modest fee where they will talk to the other party. That keeps us prospective mediators pure and uninfluenced. And when both sides agree, we can get on with it. So how do we choose a mediator? Now we've got to that happy stage. Well, if you Google Mediator UK, you will find hundreds of entries, hundreds. You really will be spoilt for choice. So what do? The first thing I would say is you must choose a mediator who is approved by the Civil Mediation Council. We, are the properly trained people. We carry professional indemnity insurance, and we are subject to regulation by the council and to disciplinary proceedings if we make a mess of things. So do get a CMC registered mediator and you will feel a lot more secure. Do not be persuaded that for a mediation of a particular type, you need an expert in that field. Do not be persuaded that because there's law involved, you need a QC who's a mediator. Not necessary. That for property matters, you need a chartered surveyor. I've regularly mediated housing disrepair, rights of way, all that sort of thing to do with property. I'm perfectly capable of doing that just as a chartered accountant. What you really need is a mediator who is an experienced mediator. You need a mediator who can suggest novel solutions, who's a good listener. And in that we are trained that we have only one mouth and two ears. Now, it may surprise a lot of you who know me, but in fact, I think I am a good listener. I do know when to stop talking. And at the end of the day, what you really need is a sort of a social worker, somebody who can listen and find out how people really tick, what is really bugging them. It's surprising that although we get mediation position statements and sometimes quite a lot of material sent to us a few days before a mediation, which I do carefully read, that on the day, something comes out in conversation which tells you that it's actually got very little to do with that. It's more a cry for help in something else which you can now work on. If you want to find an approved list of mediators, rather than Googling Mediator UK, look at the Civil Mediation website or Mediator Network itself. We have a stable of experienced mediators. The Academy of Experts, where I am a fellow, has an excellent expert search facility for experts, for mediators, for expert determiners, and so on. And Clark's Room, for a fee, will find you a mediator as well. There are many other lists of approved mediators available. How then do we prepare for mediation? Well, again, and I'm sorry, I'm not. My job today is not to sell hits on my website. I know I've mentioned my website a few times, but it does have a lot of material which is relevant for what we have to do. There's a section on mediation preparation, and what I'm about to talk about does come from that area. Lawyers or others advising parties in dispute should ask their client what is their best outcome, what are their red lines, what is their reasonable outcome. Those of you who saw Sue Bayram's mock mediation this morning will see she made reference to the 3 eggs, which she's going to make available to us all. She's shared that with me quite a long time ago, and I use that technique. When writing out to the parties and advising them to prepare, on the simple mediations, we give them pictures of 3 eggs. Now, right under the brass egg, what it is that wouldn't be acceptable. Right under the silver egg, what it would be nice to have. And right under the gold egg, what would bring all your wishes into fruition at once. So there are 3 levels. You can then see those notes should be shared with the mediator, but not with the other party. The mediator then knows where each party is coming from, what they seek to achieve, and what their red lines are. But for anything but the smallest mediations, I send out a checklist. Now I'm going to spend a bit of time on the next slide and onwards on this checklist, because it does go through exactly what one should do to prepare, to get the parties to think about what they really need. You, of course, must send a mediation position statement, no more than 1 page. I've seen 15-page position statements. Waste of time. 1 page is plenty, with key documents. But I've seen solicitors who photocopy the whole of the contents of their filing cabinet and send it to me and say, that's what it's all about. Well, okay, I've got to spend extra to read about 15 ring binders. But when you get to the day, what you're talking about is nothing to do with that. Dig out the key things that matter. In other words, keep it simple and don't be stupid. KISS. Right then, the confidential checklist. As I said, there's a lot of detail here. I will scamper through it as fast as I can. The party is to write down their own answers to these questions. What is the case about? 2, list the evidence you have to support your case. 3, identify any issues which are not supported by evidence and think about whether you could obtain the evidence before the mediation. 4, what monetary outcome do you seek, or does the other party seek if you are the defendant? Now that will come from the claim form if proceedings have been started, but we want to know anyway. What non-monetary solution do you seek? That they stop harassing me, that they stop trailing across my back garden, that they stop parking their car at the head of my drive, whatever it is. And what does the other party seek? List the arguments that support your position on liability and on compensation. List your strengths and list your weaknesses. Okay? I won't go through the other slides in such detail, but the next one is the reflection of that. What you should do is pretend to be the other party and answer the same questions. In other words, where is the other party coming from? What do you think of their strengths and weaknesses? What do you think they really want? And so on. Now, if answers to these questions are shared with the mediator, but not with the other party, the mediation can hit the ground running. It saves a lot of time, and it's a lot better than reading 15 ring binders of documents. Next page of the checklist. The written summary, and this is what it should contain. This is the one-page summary. Details don't matter, we can look at it later. Then, who are the decision makers? Who exactly will be attending the mediation and in what capacity? Now, I've had mediations ranging from Billy No Mates coming entirely by himself, right up to QCs with juniors and solicitors. I've had solicitors, I've had Mackenzie friends, I've had wives, husbands, great aunts, whatever. It doesn't really matter, except that I need to know in advance who's coming, and the other side need to know. So that, for instance, if a QC is coming for one side, the other side may wish to do the same. They perhaps don't know that when it comes to it, I'm really good at David and Goliath situations. I'll put the QC in a room and get him to do some work so I can talk to the people that matter. Try to get him out of it in the way. But I have come across mediations where the QC stands up, puts his thumbs in his waistcoat and starts to give us a long speech. You know that that's going to be an uphill battle. That should really be avoided if it can be. But are those people the ultimate decision makers? I've had mediations, particularly groups of Asians, for instance, who will break off and ring an elder in the community. And what they're asking is, look, the way this discussion is going is this. I might have to agree to this. Do you think, elder, that I will have my, I'll be able to hold my head still up high if I agree to that in this mediation? That's really difficult because the real decision maker is somebody I'm never going to meet, and we've got to deal with that. If it's an insurance claim, I need to know that the claims manager is available. I've only ever once had a mediation where the claims manager actually attended the mediation and his involvement was magical. In fact, that is one of the example mediations I come to at the end. So we'll just wait for that one. I refer to it as the Billy No Mates mediation, where I had a claims manager and 6 lawyers on one side, and the claimant came along entirely by himself without even a newspaper to read when I was talking to the other party. That really was a gross imbalance, and I'll tell you later how we dealt with that. But for instance, if you do need, if the wife needs to ring husband to say, I might have to settle for this, what do you think, love? She'll know his mobile, that's fine. But if the real decision maker is the claims manager, we have to be sure that we have that guy's mobile number and we can ring at midnight if necessary.
You don't know if they are right, actually.
Sorry? Okay, moving on. If there are proceedings in issue, we need to know what the proceedings are. We need the claim form and the particulars of claim, what stage of disclosure has been reached. Make sure the mediation does not get bogged down with a massive paperwork. This is not a trial, and the parties do not need to win on every point. We're not bothered about the past. We're bothered about where we are now, where we're going to go forward, and it's the big picture that matters. But if any admissions on record have already been made, clearly we need to know about it. Am I delivering it about the right speed? Yeah, thank you. Okay. Well, I've seen one thumb, so I'll press on. Stage 6. Now, this is where we really get down to it. What do you, party, want out of this mediation? This is the eggs, the brass egg, the silver egg, the gold egg. What would you like to get? What would you be happy with? What would you really accept? What is the one that you could never accept? At what point would you walk away? How did you value how much you'd been claiming and what elements are included? But out of that, what would you be able to live with? Costs. How much have you spent so far on legal costs? And in particular, how much would you have to pay to lawyers in future if today fails? And one of the extreme examples I give at the end is of a case that had £300,000 of future legal costs per party. So the person that lost at trial would have gone down for £600,000. Fortunately, that mediation settled. So think, party, what's your chance of winning at court? And does your solicitor agree with that chance? And at that point, I could turn to the solicitor and say, are you really telling your client that you've got a 100% chance of winning this case? If so, why do you think the other people in the other room are perhaps thinking similarly? How can both not be right? And I'm quite cheeky about obliging the legal advisors to stand by their opinions or perhaps soften it, which is part of finding the middle ground. How much of your time will you have to spend with lawyers over the next 12 months when it gets up to trial? Or quality family time? What reputational damage might be suffered? And that again is an example I think I use at the end, which is of the sports car, the very expensive sports car that burst into flames 5 times. And if that ever got to court, just think what damage that would do to that brand of car. The defendants were desperate to keep the case out of court, to keep it confidential. So you've got power balances to think about all the time in mediations. And then what questions would you like the mediator to put to the other party in private? Well, that's sort of prior notice of what might be needed. Obviously, during the day's discussions, that's something that you constantly ask. What do you want me to say to them? Am I allowed to say this? Whatever. And then the touchy-feely bits. What do you really want to achieve? What would it mean to you if you did? What do you need the other party to say to achieve this? With clinical negligence, what the parents of a baby who died because of neglect or whatever want more than anything else are 2 things: an apology and an assurance that the doctors in the hospital have tightened their procedures so that no other parents would be in the same position. An extreme example of that was the Alder Hey Children's Hospital case, where a Norwegian consultant working at the hospital had actually harvested organs from dead babies without the parents' permission, and had kept them all in jars in his surgery, and those parents had buried their own children without knowing they were incomplete. You can imagine how devastating that was when it came out. That dispute was mediated. The solution was an apology, a tightening of procedures, and at the hospital's cost, the building of a peace garden in memory of those babies. That is a real touchy-feely bit. And that is what was important to those parents. What are your main concerns? What do you think the other party is concerned about? How may misunderstandings have arisen? And why do you think the other party has come? What do you think they're going to say? Now, that is my last page of the confidential checklist, but you can see it's very deep. And if I get those replies before the mediation starts, I'm in a very good position to help the people who are in these difficulties. If not, you've got to dig out the same answers during the mediation, but it takes time. On the day, do arrive on time. The mediator will want a brief chat at the beginning. By the way, this is physical mediations. It's all out of date, really, because we always do things by Zoom. But we can have a brief chat anyway, and we get the mediation agreement signed up so everybody's happy with that. Make sure everybody's comfortable. Do gather for a joint session. I am a very strong believer in the joint session. It makes people meet the others. They don't have to have eye contact. We can sit around the boardroom table so they don't have to look at one another. But I do need them to, excuse me a second, I do need them to be there, and I do need to hear the sound of their own voice, where for 5 minutes they explain their own case. 5 minutes uninterrupted. We may have a joint session continuing, if only to sort out what it is we need to address. Then we go into caucus, and the mediator does the Henry Kissinger international negotiation, shuffling from room to room and finding out what each side wants. For those caucuses, the parties have to be fully open with the mediator. Common issues are explored, and don't forget the mediator knows the full story and no one else does. Surprising how often I am aware that we are fairly close to getting a settlement here, and the parties in their separate rooms have no idea. They think we've been talking here for hours and getting nowhere. And I do ask them not to be despondent, because 80% of mediation settle, and this is going to be one of them. The mediator's challenge is to find the common ground, a situation that all parties can live with. That's not a total winner and a total loser. That's what happens at trial. One wins and gets the legal costs. The other has blood on the carpet. We're not like that at all with mediation. If I'm engaged as an accountant mediator, say for a partnership dispute where they can't agree how much each should take out at the end of the partnership, I often have an Excel spreadsheet ready where I can pop figures in and we can automatically calculate, if I agreed to this, what would I have to pay or what would I receive, and so on. So that can be a mobile technique for discussion. And when agreement is reached, that is evidenced by a Tomlin order, if proceedings have started. Tomlin order is simply a very short summary of what's been agreed, and it's addressed to the court and says, court, we don't need a trial anymore, we've settled. But it's also a legal record of what the parties have agreed, or the settlement agreement, which is more informal but equally effective. I generally take pro formas of Tomlin orders and settlement agreements to the mediation and set up my notebook and printer and say at the beginning, look lads, lasses, we had to agree today. Your agreement's in my notebook. I only know the number. I'll type it in and we can go home. So let's get on with it. Hopefully that built some confidence. With a Zoom mediation, rather than the hard copies I've mentioned, it can be evidenced by an exchange of emails. So what happens afterwards? With a Tomlin order, the claimant has to file that at court and tell the court we don't need a trial anymore. The parties have to carry out what they promised in the agreement. If they don't, that is grounds for a specific performance application to the court, and the court would go for a summary decision. It would be a very inexpensive and very brief hearing where the judge says, look, you agreed to that, now you've got to do it. So they then get a court order of what had to be done, reflecting what it is they had agreed but hadn't done. And then what happens? You get the parties with a look on their face saying, I don't know what I'm going to do with the rest of my life, because it's over. They've been fighting it with such a passion, sometimes for years. My record was 22 years of dispute leading up to a mediation. But then it's over. And they can take up a new hobby or whatever, join the Lions, do whatever they wish. So how do you get the best out of a mediation? Act throughout in good faith. Tell the mediator everything. He won't tell the other side except with permission. Do understand that your opponent has a point of view, or they wouldn't be there, even if you don't agree with that point of view. Try to understand it, try to understand why it's wrong and what you can do to persuade them that it's wrong, or possibly meet them part way on what they're arguing. Do be fully prepared. I mean, if you do my confidential checklist, you could hardly be better prepared. Keep it simple. We're looking at the big picture. We are looking at where to go forward from here. We are not into recriminations. But you said so-and-so 5 years ago. Sorry. Why does it now matter? We are where we are. Let's solve it. And please, no long speeches. Look forward to possible solutions. Do not rake over the past. And all the time, think positive, remembering that 80% of mediations do settle. And even if they don't, you'll probably get a lot out of it because you've learned a lot about your opponent. You can now frame a far more carefully prepared Part 36 offer to settle and see an end to the thing, or perhaps talk kindly to the person you now know far better and settle it that way. Right then, this is getting close to where we have audience participation. But let me very briefly, and I will be brief as I can, go through some of my past mediations to show you what it was that I learned. The first one is the grandfather clock. Anybody interested in the clock? This was a probate dispute where mum had died. There was a big dispute over a sizable estate, and brother and sister were in conflict. They hated and despised each other with a passion. He despised his sister because the minute she got to age 16, she got married, left home, and did nothing for her mother after that, leaving brother at home to look after mum during a long illness. She despised him because when eventually mum died, he went off to Thailand, the tattoos, the drugs, the child sex, all the horrible things that one can do there. And she found him a terrible example of humanity. And it was a nasty mediation. A lot of bile came out. And I learned that mum's furniture had all been put into storage, and sister was resentful of the storage charges. She wanted to get rid of the furniture, but felt that she couldn't. So I said to the brother, is there anything out of that furniture that you perhaps would like to keep as a memento? He said, yeah, you're right. I want the family grandfather clock. I wound it every night when I went to bed after I've made mum's supper, and I want to keep that. It's a good memento. Went into the sister's room. Are you fond of anything particular? No, I just want it out of storage. Not even the clock? No. Would you mind if your brother took it? No, chuck it to him, I don't care. I went back to the brother and said, I think I've won you a grandfather clock. And you know, because they agreed that point, everything else melted away and we managed to settle it in no time. The next one is the £600,000 legal cost one, the propounded codicil. A man had died and he'd had 4 wives, probably women in between as well, we don't know about that. He had had a very carefully arranged will with effective tax planning. The 4th wife had actually never lived with him because he went ill as soon as they were married and was in hospital and then died, persuaded him on his deathbed to alter this will to give her a very much larger share of the estate. That, not unnaturally, was seen as an unfair challenge, as unfair influence. So it was propounded. The other side contested it. The other side was the 2nd wife. Now, the 2nd wife had been in partnership with husband up to 22 years earlier as property developers. They had shared out the properties when that partnership came to an end, and she took the mansion on the Hamble. It was a colossal house. She lived in it all alone. She had no relatives. But because it was worth more than the half share, she'd had to give the husband a mortgage. Nothing payable on it, but just a charge over that house. What she wanted was an equity release scheme to get money to live for the rest of her life, because she couldn't afford to live there. But the mortgage that had been given to the husband prevented any inferior charges. So the equity release company couldn't take a charge on the property, couldn't give her any money. I asked solicitors on both sides what it would cost to take this to court. Each of them said £300,000, so that's 600,000. We settled with a more modest amount to the 4th wife and an agreement that the mortgage, which she now inherited, would be changed so that inferior charges could be allowed. So the 2nd wife got her equity release. Now, my fee for that was about £3,000, which is very much fewer notes on the end than 600,000. Magic. The sports car that burst into flames. This was very, very interesting. This guy, who was actually in the motor trade and had numerous cars already, bought his wife a very expensive sports car. It cost about 70,000 for a birthday. She loved it, but it had a fault. It kept bursting into flames. On the 5th time, in the garage, and nearly took the house down. So the guy rejected the car, but it was more than 6 months after they'd bought it, so the dealership refused to take the car back. We had 4 parties at the mediation. We had the claimant, the husband, we had the car dealership, we had the finance company, because for some reason, I don't know why, the husband had bought this on a finance deal, so it actually belonged to the HP company. And we had the importers, the manufacturers. You can imagine what damage it would have done to that mark of car if this had got to court. They were absolutely desperate to keep this out of court. So I asked the importers what they were going to do about it. They had an in-house counsel with them who was very, very bright. They said, oh, we don't like unhappy customers. Tell him to give us the car back. We'll buy him a new one. He can just run it. If he doesn't like it, we'll give him another one after that. We don't mind. So I went into the husband's room and said, I've got you a new car. What make? Same as you've got. Tell him to, unrepeatable. In other words, it went down like a lead balloon. So I went back into the importer's room and said, sorry, wasted time. And they said, well, you may have noticed that we also import this other mark of car. Let's call it a Lamborghini. It wasn't a Lamborghini, but let's call it a £200,000 car. See if you'd like one of those. Now, this was double the price of the car that they were talking about. And his eyes lit up, and we spent a happy afternoon specking up this car. What colour do you want? What upholstery? What about a close ratio box, limited slip differential, Alcantara seats, paddle changes, everything. Wonderful. And he made it clear that he didn't want the car really. He was going to sell it. Now, the importers forbade their customers from selling their cars, and they didn't have a right-hand drive one anyway. But they said, don't worry, we'll find one, and if he wants to sell it, he can. That clearly settled. Why? Because the true needs of the importer was to keep out of court the bad influence that would have got of a car that burst into flames. Number 4, time is going on. I'm going to skip. It's rather complicated and it takes a while to explain. But number 5 was the tax negligence case where I co-mediated with Sir Alan Ward. It was a £500,000 tax negligence case. Alan was the grandfather who smoothed things over. I was the heart cop, and I borrowed the defendants. It was a national firm of accountants. I borrowed their working papers file and was able to see that this £500,000 negligence claim was of no merit at all, and was able to tell the claimant, who was a very prominent knight of the realm, a businessman, that he didn't have much of a case, and so it settled just for £10,000 to £20,000 nuisance money instead of £500,000. And the final one is partnership dispute. I was appointed as single joint expert by 2 parties. One party was a firm of accountants up in Newcastle. The other was a partner in that firm who had decided to pull out, to take his clients with him, and to take his key staff. Obviously, the ongoing partners were quite upset about that, and they wanted him to pay for, excuse me, I keep pressing that. This is your page that's coming up, by the way. Wanted him to pay the value. I said after I had to go and interview both sides, and after that I said to both solicitors, I think I know these people very well, that we've a very good chance of mediating a settlement here. Do you want me to do that? And they were nervous. They said, well, yes, but if it does fail at mediation, we'll have to start again. And we'll even have to appoint a separate single joint expert, because we can't use you. You'd now be influenced. I said, well, as an alternative then, what about expert determination? What's that? So I explained, and they went for it, and I was appointed the expert to determine the matter. I'd already knew about it, so it was a very simple thing for me to make a decision. And I said, the partner who left has got to pay this amount of money to his old firm for the practice that it's taken over. The model there is there's more than one way of skinning a cat. And I'm going to finish with number 6, which again is very, very interesting. This is the Billy No Mates, where the chap came to the mediation with nothing and was about to fight a High Court action on a £500,000 claim. And in the other room, we had the 2 lawyers who'd drawn up an agreement, which was the subject of the dispute, with 2 lawyers from the insurance company, with 2 lawyer trainees, and with the claims managers. So that was 7 actually in that room. As this chap came with his case, what he said was that his father, now dead, had instructed the firm to draw up a post-nuptial settlement. In other words, after marriage, that the house they lived in, which was in St. John's Wood, a very expensive house, would be given to the son and son-in-law, Billy No Mates and his wife, but if the marriage came to an end, it would revert to the father. Now, those of you who know any family law at all will know that post-nuptial settlements really cannot work, because it's something that's been brought into the marriage after the marriage, and must be regarded as an asset of the marriage. So that settlement was never going to work. That was worth the £250,000 the chap had to pay to get his share of that house out of the marriage. So he was suing for that. But he was also suing for another £250,000 for pain, suffering and loss of amenity, for all the trauma that he'd gone through by having to fight this case. And that in civil and commercial law is a complete non-starter. Pain, suffering, loss of amenity can only be claimed in a personal injury or fatal accident case. And I knew that, but as mediator, I couldn't tell him that. So what did I do? I went into the room full of lawyers and I said, I want two of you, no more, to sit in the other room. I'll be the referee. I'll blow the whistle if it gets nasty. And I want you to explain to Billy No Mates why he has misunderstood the law. The outcome was that they agreed to pay him £30,000, which was just a nuisance value, which was the amount within the insured firm's negligence agreement. That was the first part that they had to pay themselves. So it cost the insurance company nothing, except the claims manager was there and he wanted an end to this case. And he had already paid to the insured firm legal costs of £169,000. And he said, if we get a settlement today, I'll write that off. How powerful it was that the claims manager was there. And you know, Billy No Mates went home with 30,000 instead of £500,000, and you would not believe the thank you letter he wrote to me, because he'd have had to represent himself in court and he just hadn't a clue how he was going to do it. So it was over. And his problem was, what am I going to do with the rest of my life?